Marine genetic resources in areas beyond national jurisdiction. Do we need to regulate them in a new agreement? This paper seeks to question the prevailing orthodoxy on the need for the package deal on the proposed international legally binding instrument under UNCLOS on the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction to address marine genetic resources, including questions relating to access and benefit sharing. Through an examination of key documents and reports prepared over the past 2 decades, the first part of this paper will show that there has been little hard commercial evidence brought forward during debates at the United Nations to justify the inclusion of the marine genetic resources issue within the package deal. In light of that analysis, the second part of the paper will then go on to offer some initial thoughts on the various options for regulating access and benefit sharing in relation to marine genetic resources in areas beyond national jurisdiction that have been floated during the initial phase of negotiation. In particular, the second part of this paper examined the possible element of a draft text of an international legally binding instrument set out in the chair's non-paper considered at the third session of the preparatory committee established by General Assembly Resolution 69 per 292. The paper doesn't seek to trace the extent to which aspects of the chair's non-paper ultimately were contained in the PrepCom's final report to the United Nations General Assembly in late 2017. These negotiations are still ongoing, and nothing definitive can be read into what present or absent from that report. Instead, this analysis highlights which proposed element of the international legally binding instrument would be the preferable outcome from this negotiation in light of the lack of evidence of commercial interest in marine genetic resources in areas beyond national jurisdiction. On 19 June 2015, the United Nations General Assembly passed Resolution 99 per 2921, which committed states to develop an international legally binding instrument under the 1982 United Nations Convention on the Law of the Sea or UNCLOS on the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction. Critically, Resolution 69 per 292 mandates that the international legally binding instrument must address the topic identified in the package agreed in 2011, namely the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction. In particular, together and as a whole, marine genetic resources, including questions on the sharing of benefit, measures such as area-based management tools, including marine protected areas, environmental impact assessment and capacity building, and the transfer of marine technology. In essence, Resolution 69 per 292 set up the negotiation for an international legally binding instrument under UNCLOS on the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction as a package deal, that is to say, all issues are to be addressed or no issues will be addressed. This approach to the negotiation of an international legally binding instrument should come as no surprise to even the most casual observer of this debate. These issues have become increasingly intertwined in the discussion at the United Nations or UN over the past decade and a half, especially during the work of the ad hoc open-ended informal working group to study issues relating to the conservation and sustainable use of marine biological diversity in areas beyond national jurisdiction. All the issues relating to the conservation and sustainable use of biodiversity in areas beyond national jurisdiction or ABNJ are interrelated and are best addressed as a package deal, assuming that each element of the package deal actually merits regulation. This paper seeks to question the prevailing orthodoxy on the need for the package deal to address the marine genetic resources or MGR issue, including questions relating to access and benefit sharing. Through an examination of key documents and reports prepared over the past 2 decades, the first part of this paper will show that there has been little evidence of commercial interest brought forward during debate at the UN to justify the inclusion of the MGR issue within the package deal. In light of that analysis, the second part of the paper will then go on to offer some thoughts on the various options for regulating access and benefit sharing in relation to MGR in ABNG currently on the negotiating table. In particular, the second part of this paper examines some aspect of the possible element of a draft text of an international legally binding instrument set out in the chair's non-paper, which was considered at the third session of the preparatory committee established by General Assembly Resolution 69 per 292. The analysis in the second part of this paper will highlight which proposed element of the international legally binding instrument would be the preferable outcome from this negotiation in light of the lack of evidence in relation to commercial interest in MGR in ABNG. It should be noted, however, that it is not the author's intention that this final part of the paper trace the extent to which aspects of the chair's non-paper ultimately were contained in the PrepCom's final report to the UN General Assembly in late 2017. Given the negotiation for the international legally binding instrument are yet to be concluded, nothing definitive can be read into what was present or absent from that report. Some of these elements may or may not ultimately be incorporated into the final international instrument. Instead, the aim of the second part of this paper is to highlight what in the author's view will be the optimal outcome on some of the key issues which have been flagged in the chair's non-paper. Whether this optimal outcome will or will not be achieved, it is too early to say. Alternate facts and debates on marine genetic resources. In a recent opinion piece published in The Guardian, cell biologist Jenny Ron from University College London lamented the recent jaw-dropping performance of Donald Trump and his cronies firing off random statements without even bothering to check whether they are true is disturbing as the fact that they seem to be getting away with it. It is no longer enough for a reputable press outlet to cry foul. The correction are shrugged off as partisan conspiracy theories, and the expose no longer leads to shame or the mending of ways. Say something loud enough and often enough, and it starts to sound true. Get away with it enough, and it becomes a viable strategy. While that commentary related to attacks on science and scientists that regrettably have come to characterize what passes for policymaking in the post-truth world of the Trump presidency, it is arguable that a similar phenomenon can also be observed in debates on MGR at the UN over the past decade and a half. That is to say, certain alternate facts relating to the level and extent of commercial interest in MGR in ABNJ have repeatedly been asserted loud enough and often enough that they have now come to be accepted as fact, even though the supporting evidence for this claim is woefully lacking. Thank you.